You've probably heard this one before. Founders and early team members can work for free until either the first funding round or we actually start to make some money. Right? Wrong. This is a dangerous myth and it is not legally true. Whether you realize it or not, you as the founders and your early team members are the company's first employees. This is a crucial and often missed compliance point that can lead to substantial liability for your business. Failing to comply with the Fair Labor Standards Act can lead to massive liability for unpaid back wages and liquidated damages. My name is Maritza Shay Nelson, and I'm a small business and nonprofit attorney. I help entrepreneurs, founders, dreamers, and innovators pursue their passion without worrying that all this legal stuff, like the Fair Labor Standards Act, might come back to bite them. There's a sort of romanticized image of a startup, the all-night coding sessions or late hours after your 9 to 5, fueled by ramen and just ambition, where you and maybe even some of your early team members are toiling away until the wee hours of the morning, working without pay until money actually starts to roll in. But this is a myth. Even more, it's a legal trap. The common belief that you and your first kind of early folks on your team can just work for free until the money shows up is fundamentally false and incredibly dangerous from a compliance perspective. Legally, from the moment the business is first formed and operational, you as the founder and your early team members are considered the company's initial workforce. You're the first employees. And as the founder, you're not liable to sue yourself, but your team members, they might. This often overlooked reality brings the startup squarely under the umbrella of critical labor laws, most notably the Fair Labor Standards Act or the FLSA. And not complying with the FLSA is not just some minor nitpicky oversight. This creates a massive retrospective liability for the business, exposing it to claims for unpaid back wages, liquidated damages, which can sometimes double the back wages that are owed, and even attorney's fees. The FLSA mandates that virtually all employees in the U.S. be paid at least the federal minimum wage, and unless an exemption applies, overtime pay for hours worked beyond 40 in a work week. Now, the primary mechanism for you as the founder to legally bypass the standard minimum wage and overtime requirements is the business owner's exemption. However, this exemption is narrow and strictly defined. To qualify, you as the founder or one of your fellow co-founders must satisfy two criteria. First, you have to have a significant equity interest in the company. So we're talking about at least a 20% interest. And second, you have to be actively engaged in the management of the business. So if you have a co-founder who maybe is more of a silent partner, they don't meet the criteria. Those early team members or service providers that you bring on, maybe with the promise of a small stake in equity in exchange for helping to build it up, well, they don't have a high enough equity interest, so they're not exempt. Or they're not actively involved in the management of the business, so they don't meet the qualification for the exemption. Anybody who fails to meet both the 20% ownership and active management requirements is legally entitled to minimum wage and overtime. So when a company fails to formalize this employment relationship, this long history of noncompliance becomes a potent legal weapon against the company, especially when that key person leaves under less than friendly circumstances. So how do we deal with this? The reality is that most bootstrap startups cannot sustain immediate full market rate salaries, and this is often why you're not paying yourself as the founder, and you're trying to get people to come on, and you're offering them a small stake in my startup in exchange for XYZ service. But that's a legal risk, as we've talked about. So what do? There are three common approaches to managing this FLSA compliance. The first, the most risky, of course, is the risky silence. We don't sign any documents. We don't deal with the employment question. Maybe we sign that PIIA or Proprietary Information and Inventions Assignment Agreement that we talked about in the last video, but otherwise we remain silent when it comes to issues like salary, and we just don't deal with it until there's actually money coming in. Here, you're not legally compliant, and you're at the highest risk. You're opening yourself up to massive FLSA liability from day one. And this is the default behavior that we see from a lot of startups. And it's fine when you're asking your best friend to maybe build the website or help you out with the software development. But it's the one that's going to lead to a legal crisis when that best friend walks away and they're now disgruntled and they want to make the argument that they should have been paid. The middle ground, which is one that we see quite often, is this sort of deferred payday. You might sign an offer letter or an employment agreement, or you might have a key person sign one of these documents, and it specifies a compensation mechanism that's compliant with the FLSA. It might be minimum wage, or it might even be an exempt level salary, but you actually acknowledge in writing that, hey, we're not actually going to pay any of this money until some funding milestone has been reached. This might help to minimize the fight risk, but you're still not fully compliant. While the intent is clearly documented, the failure to actually pay the compensation is still a violation, especially when it comes to the fact that you have to timely pay people their wages. So it might serve as a good faith defense. Maybe you can make that argument, but it's certainly not watertight. Your best practice, so your full compliance, founders and key personnel sign an offer letter. It specifies a salary that meets the exempt threshold. So an exempt threshold under the FLSA is currently, at the time of recording, $684 per week, which translates to $35,568 per year under federal law. Still got to check your state and local laws, and that number's changing all the time with politics. And the company actually pays that salary from the start. Again, tough to do when you're a bootstrap startup, but that's going to be your best practice. That's what's going to allow you to be fully compliant. And it's the lowest risk. It's the only path that guarantees full compliance with both the Fair Labor Standards Act and your state-specific labor laws, and eliminates the risk later that that key person who was just helping you out comes back and later sues for back wages. Now, federal Fair Labor Standards Act compliance is only half of the equation. A critical detail that founders must be aware of is that state labor laws can be significantly stricter and impose additional requirements that could supersede federal rules. For example, some states, especially states like New York and California, don't have a direct comparable exemption to the business owner's exemption. These states often have higher minimum wage laws, more stringent requirements for exemption from overtime, and even specific wage payment laws detailing how quickly and how frequently wages have to be paid. If you and your co-founders or early team members are working from or residents of different states, your compensation plan must be reviewed against the laws of every state involved. The law that matters is where that person who's working, it's where they are. Failure to do so means you could be compliant federally, but wildly out of compliance in a high-risk state like New York or California. So it's absolutely critical as a founder that you consult with an attorney to ensure that your formal employment plan actually complies with both federal and all of the relevant state and sometimes local specific minimum wage and overtime laws. Proactive legal counsel means you get practical, real-world advice, not just legal theory. Don't let a compliance issue from day one sink your company later. My clients range from startups to growing businesses and nonprofits with nearly 100 employees across a wide variety of industries. If you love what you do and want to build something amazing or take amazing to the next level, then let's talk. Check out the link in the description to schedule a consultation. In the meantime, don't forget to like, comment, and subscribe, and hit that bell notification to be notified when we drop a new video.